Good morning, everyone. Thanks for joining us today for part 2 of the webinar series entitled Demystifying Leaves of Absence, Expert Guidance for California Businesses. As I mentioned, this is part 2 of a series presented by Ethos Human Capital Solutions and Merhab Robinson and Clarkson Law Corporation. My name is Denise Ketty, and I'm your moderator for this session, and I'm just going to go over a couple of housekeeping notes, and then we'll start. The webinar will run approximately 60 minutes. We will have Q&A at the end. I will continue to drop the link into the chat for you to download the slides, so don't worry if you miss it right this minute. If you have to leave the webinar early, please know that it will get posted on both organizations' YouTube channels. If you have questions during the presentation, please post them in the Q&A area on the dashboard at any time. If you want your question addressed to a particular panelist, please add that to your notes. If you have any issues, you can text me, or actually you can email me during the presentation at denisemketty@gmail.com, or just try to put something in the Q&A and I'll get back to you. Quick reminder about today's webinar. Today's webinar is being recorded and all accompanying materials are protected by copyright. Our presentation today is intended for information purposes only and should not be relied on in reaching any kind of a conclusion in any area of law. The information offered is good as of today, May 9th, 2024. As always, we recommend you consult with your own legal counsel to address your specific situation and ensure you have the most current information on your legal matters. Our webinar today has been approved for 1 hour of HRCI credit. If you want a credit for your attendance, please complete the follow-up survey. Again, during the session, as the presenters are improving, I will drop the information into the webinar chat so you can get that code. You have to do the follow-up survey, and then you will get a certificate. You can go to the next one. Okay, let me introduce you to our legal panel today. Our expert is Curtis Urian. He is the associate with the firm Merhab Robinson and Clarkson, and he has been in the firm's transactional department for 8 years. He advises clients for real estate, finance, business succession planning, corporate and employment law. Curtis has been contributed to law journals, articles. He's been a part-time lecturer. He teaches classes in economics and conscious capitalism and business law, and he has been recognized as a rising star in Southern California by superlawyers.com for the last, since 2017 to 2024. Our next presenter in HR is Linda Duffy, president of Ethos Human Capital Solutions. Linda and her team are known for building the magic of the human connection with their consulting, recruiting, training, and payroll support programs. The Ethos team works with your company by developing strategies for your business leaders to get the right systems, people, and culture in place within your organization, so you as a business owner can focus on running your business and achieving your goals. Linda, we have a lot to cover today, I know, so can you get us started this morning?
I sure can. And I just want to remind everybody, this is part 2 of a leave of absence series that we've done, because there's so many leaves of absence that California employees can take. So the first leave that we did last month had to do with personal leaves of absence for somebody's own medical condition primarily. So we covered everything you see listed there. And if you missed it, you can go out and watch it on the YouTube channel, and I've provided the link there. Today's webinar is going to focus on the other 21 leaves of absence, and yes, 21 it is for California employers. So we'll go through those, and then we will take your questions and provide answers for you at the end. So as Denise mentioned, you can drop those into the question and answer section or the chat or wherever you want them, and we'll get back to you at the end of time. So Curtis, the first few leaves of absence we're going to talk about are military related, starting with the U.S. military leaves law. So this one applies to all employers. What can you tell everybody about this?
Yeah, this is a federal law that applies to all employers. And you'll see in the next few slides that there are some state-specific laws in regards to U.S. military leave. But this particular law is federal law and applies to all employers. And it applies the eligible employees that can take U.S. military leave law. The eligible employees are employees who enlist in the military service who perform military reserve duties. And we've listed on here the qualifying events of enlistment or call up to perform duties. And the little length of time is however long the assignment, the active duty assignment is. And the employees are required to provide advance notice. This typically comes up in the context where you have an employee that's, say, a reservist or an employee who's not, or yeah, an employee who's not on active duty but may be called up to active duty. And so this is a type of protected leave for those employees when their service is over. This law guarantees that they can return to their employment after serving their country.
Yeah, and this is the longest leave that I can think of, Curtis. It can go up to 5 years. I don't know of any other leave that comes close to that. Do you?
Not that I can think of.
Yeah, unless, of course, it's a personal medical thing that gets extended and extended and extended some more. But this one,
Right.
5 years is a lot. So California, of course, can't be outdone by the feds, so they had to come up with their own. So this one is for members that are in the reserve or get called up for some specific military obligation they have. It can be for training as well. And it's 17 days if you're a private employer. And then if they work for the government, it's 180 days. And like Curtis said in the federal one, this does have a guaranteed right to reinstatement to their prior position. So that's something to know about this one as well. So Curtis, then we have something for the spouses.
Right. So our country is privileged to have many people who volunteer to serve in the services in our armed services. And so often when a member of the armed services goes off on active duty or goes off on deployment, their spouses are left to try and take care of their families or engage in other activities. So there is spousal military leave, and this only applies to employers with 25 or more employees. And it's for employees who are spouses of qualified members of the armed forces, National Guard, or reserves. And the qualifying events would be, like we've discussed before, active duty for or deployment for National Guard, Armed Forces, Reserves. And it's 10 days of leave during a qualified period. And the requirement is that the employee must be reinstated from returning from this leave, and the employee must provide 2 business days of advance notice, or must provide notice within 2 days of receiving notice that the leave is necessary.
Yeah, and I think this was intended so when the spouse comes home on a leave from duty, that this spouse can spend some time with him or her. Right.
Sure.
So that was the original, I think, intent about this one. And then we have the Civil Air Patrol Employment Protection Act, something I've never once had anybody take. Curtis, I don't know about you, but this implies. I'm sorry.
I've not known anyone who's taken this leave. I have met members of the Civil Air Patrol.
Have you? Okay.
I have, but I've never had anybody or worked on any matter where an employee requested leave under this act.
Yeah, and this is for employers with 16 or more employees. I was thinking this morning, I wish the legislature would pick some numbers and stick with it. Is it 15? Is it 16? Is it 25? Is it whatever? Because it makes it a little crazy, especially as we're writing handbooks and stuff, to call it all out separately. So this is if, again, they get called to respond to some sort of emergency situation or get sent on a mission. So there's 10 days available, have to be guaranteed back to the same or equivalent position, and then they're required to provide notice as well.
Yeah, members of the Civil Air Patrol are sometimes assigned to participate in wildfire efforts or missing persons efforts. So it does happen. It just doesn't happen very often.
Right, exactly. Okay, and then this one about voluntary firefighters and other rescue personnel, sort of the same deal there, Curtis, right?
Yeah, kind of similar idea. These are related leaves of absence. And these are for, again, another arbitrary number. This one's 50 employees. Who knows why? But any employer with 50 more employees has to comply with this law, and it's any employee of a employer that's subject to the law. And again, it's employees that are called up to assist in wildfires or emergency rescue or law enforcement training. And it's up to 14 days per calendar year. And the employee must be reinstated when returning from the leave, but there is no advance notice requirement because this is for an emergency leave. If there's a wildfire, if there's a missing person, if there's an accident, etc.
Yeah, so employers with 50 or more have to provide up to 14 days per calendar year, but all employers have a requirement not to discriminate or discharge an employee if they take time off. So it's sort of interesting to me. It's like you can't discriminate against them if they take the time off, but you're not required to give it unless you have 50 or more employees. So figure that one out, right? Okay, the next group, Curtis, are also sort of similar or related in nature, at least in my brain. So the first one is the crime victims leave. You want to talk about that?
The law recognizes that unfortunately there is crime and there are victims of crime. And when somebody's a victim of crime, they may be called upon to testify in court at trial or at other depositions or participate in other means in the judicial process. So crime victims leave applies to all employers, regardless of size, and it gives eligible employees the right to comply with their judicial requirements when subpoenaed or ordered to attend in court. And to attend and employees can attend judicial proceedings to testify or participate with any kind of judicial process. And there is no specific maximum amount of time, because the employee might have to be readily available to show up and testify in court at any given time during a trial. We almost never know how long a trial is going to be.
Yeah, and we should also say, I should have said this earlier, that the leaves that we're going over right now, there are a couple of exceptions to this we'll talk about when we get there, but these are all unpaid leaves. So employees can, in this case, use accrued vacation time or sick time or whatever they need while they're gone, or they can just take it without pay. And then the employer does have an obligation to keep the employee's absence confidential, so you don't go around telling everybody that, they were a victim of crime. Okay, the next one, Curtis, is victims of domestic violence. So again, all employers have certain obligations, and then employers with 25 or more have additional obligations. So let's talk about those.
Yeah, and this is similar to the victims of crime leave, but it has additional protection. So it's more than just participating in judicial proceedings. It's also if someone's a victim of domestic violence, they can take time off to be relocated to a new residence that's safe and away from their domestic abuser. So there's a little more uses that are available under the victims of domestic violence leave. And if you are an employer with 25 or more employees, you are required at the time of hire to provide your employees with written notice of their rights to take leave and other rights under the Victims of Domestic Violence Act here.
Yeah, and hopefully that's being done through a handbook, of course, but you can also use documentation provided by the state. The other thing to keep in mind with this leave is if this person who has been a victim of domestic violence, is seriously injured, they may also have protection under CFRA or FMLA, depending on how large the company is. And again, you have to keep the reason for the absence confidential. And then the next one, Curtis, is really similar to this one, right? Victims of sexual assault. The rules are generally the same as those for domestic violence. So again, you have the notification requirement, and then you have a requirement to put them back into the same position once it's done. And then the next one, which is also really similar, is the victims of stalking. So
yeah, again, the requirements and eligibility are pretty much the same as the prior to domestic violence and sexual assault.
Again, wish they'd just wrap it all up in one, but yes.
Right. But they are each their own policy.
Yeah. Okay, so let's switch gears a little bit. We have the California Alcohol and Drug Rehabilitation Act. So this applies to employers with 25 or more employees, and this is for employees who voluntarily enroll in a rehab program. So if you have an employee that comes to you, says, hey, I've got a drug problem, an alcohol problem, whatever it is, and I want to enter into this, then you're going to give them the time off unless it's an undue hardship. So I think the thing to point out here, Curtis, is it depends on who goes to whom first, right? So this isn't protection for somebody that, you know, shows up to work drunk or is drug tested and tests positive necessarily. You can make it for those people, but the requirement is if somebody comes to you and says, hey, I have a problem.
Yeah, this is so when I think about this as more of a type of accommodation for an employee that's in treatment for drug or alcohol abuse. And there's no requirement, no obligation, like you said, to accommodate the drinking or the drug use, the intoxication. You can still prohibit employees from being intoxicated at work or consuming drugs or alcohol such that it interferes with their job duties. But you do need to reasonably accommodate the treatment. And one thing that is interesting here, so with this leave, there is an exception where if the accommodation creates an undue hardship on the employer, you can evaluate the accommodation request, and if the accommodation is an undue hardship, you do not have to grant it. But typically, in my experience with the Drug and Alcohol Rehabilitation Act, is these are usually people who are employees who are looking to have appointments with therapists or go to meetings after work. So it's really more of scheduling time off and whether that scheduled time off can be accommodated.
Right. And like we mentioned a couple slides ago, there may be some interplay here with FMLA or CFRA or FEHA or some other law offering protection to employees that have a serious, you know, medical condition. So you always want to reach out and talk to a consultant or legal counsel before you move forward with that. And the employee may use sick leave, you know, sick pay to cover their time off. Okay, so I said earlier that all of these leaves are unpaid except for these. And this is really, I think, the only exception that I know of, Curtis, to leaves, whether they're paid or unpaid. So this applies to employers that have 15 or more employees, and there's two different things here. One is for organ donation and one is for bone marrow donation. Again, it's been around for a long time. I've never once had anybody take it, but I'm sure it gets done because I know of people that have donated organs. So I hope that they are aware of this law and that they're aware of the protection that comes with it. So this is for the organ donation. They can have up to 30 paid business days per year for organ donation, and then another 30 days of unpaid leave if it's needed. And then for bone marrow donation, they can have up to 5 paid business days for the bone marrow donor. Now, the leaves are paid, but the employer, you can require the employee to take up to 2 weeks of earned sick or vacation leave for the organ donation first, and up to 5 days for bone marrow donation. So there's a little relief, but this is the one, like I said, or the two technically, that if are taken, you may end up paying while the person is on their leave of absence.
Yeah, it's a fairly unique law. I too have never interacted or worked on a matter where an employee requested organ donation leave or bone marrow donation leave. And this is a fairly unique law. Usually when the laws talk about leave of absence, they talk about calendar days. But for this one, it's got to be different. And it talks about the leave of absence period in terms of business days. So be sure to, if it ever comes up, be sure to make that distinction that it's not just 30 calendar days, it's 30 business days, which ends up being longer than a calendar month.
Absolutely. And I have to underline that so I remember that as well. And then the other thing that's unique about this law or these laws, depending on how you want to look at it, is the time. It specifically says in the law that the time is not counted against any FMLA entitlement. So I'm not sure why they carved that out, but they did. So it's important to note that as well. Okay, sick pay or paid sick leave. Pretty much everybody, hopefully, in California knows about this one because we also had a change earlier this year. So this applies to all employers. It's the only benefit that you're really mandated to offer, except for providing time off and things like that. But in terms of, vacation, holiday, things like that, you're not required to offer anything else, but you are with sick leave. So after somebody's worked for you for 30 days and you can make them wait 90 days to take it, if we list all the reasons here, they can now take 5 days or 40 hours, whichever is greater. We, of course, always advise our clients to front load the time off because it's a heck of a lot easier than the accrual, but you do have the right to accrue the time as well. It's just that they're going to reach that minimum pretty quickly using the state's accrual method. So it's just easier in my mind to front load it, but that's up to the each employer to decide. What do you want to say about this one, Curtis?
Yeah, this is just a general reminder of the requirements that this is a specific leave of absence. There's a lot we could spend an entire webinar on sick leave, but this is just a reminder. So if you ever have any questions or want more information, feel free to reach out to us. We've done webinars in the past on sick leave, and I'm sure those are available. But feel free to let us know if you have any questions. We're happy to help out because this does come up a lot.
Yeah, and a couple years ago, it expanded the definition for who was covered by this as well to include a designated person. So that is a little bit unusual too. So hopefully everybody's aware of that and you have that written into your policy. So it's not just the specific family members, but at the time somebody's taking sick leave, they can do it for a designated person, and it could be their neighbor, it could be their best friend, it could be anybody really. So it's something else just to keep in mind about this law. Okay, our newest leave of the year, Curtis.
Yeah, reproductive loss leave. So was actually a fan and champion of this law, and I enjoy talking about. I don't know if I enjoy it, but this is a law that I want to make sure that employers are aware of, just because I've had family members that have experienced reproductive loss, and so typically I'm not a fan of the state when they pass laws because they don't do a very good job at passing and writing and passing those laws. But I think this was a law that was justified. So the idea is that if an employee suffers a reproductive loss as defined in the law, and we've got the definition of what that means, and employees can take 5 days off that are unpaid within 3 months of the reproductive loss. And this applies to all employers with 5 or more employees, similar to the CFRA. And any employee who's worked for the employer for at least 30 days is eligible to take the reproductive loss leave. And you in the cases, let's say, because this does apply to failed surrogacy or failed IVF or IUI, those events could happen multiple times within a year. So there is a restriction that of 20 days within a 12-month period. So if there are multiple instances of reproductive loss, then an employee is restricted to basically just 20 days within a 12-month period.
Yeah, the other thing on this one is the days do not need to be consecutive. So somebody could come to you and they could say, hey, we just had an adoption fall through and I want to take the next 5 Mondays off. They could potentially do that. The other thing I find interesting, I'll use that word for this law, is that you are not allowed as the employer to request documentation. So no proof, let's say, of whatever this qualifying event is required to be provided to you. So someone could just come in and say, hey, I had this situation, and then you're going to be giving them the time off. It is unpaid, but they can use their accrued time off. And then, like we talked about with a few other of the leaves earlier, is any of those requests need to be kept confidential. You're not allowed to discuss with others why that person is taking that leave. So that one went into effect January of this year. All right, Curtis, bereavement leave has been around for a while, but it's only been a requirement since January a year ago, right? So this one applies to anybody having 5 or more employees, if they've worked for you at least 30 days, and they define the family members. And if one of those family members passes away, then again, they have 5 days that can be taken within 3 months of the loss. So Curtis, on this one, you want to talk a little bit about the pay aspect, because this one's a little tricky.
Yeah, so you mentioned before that organ leave was the only type of leave that's guaranteed pay, but that there might be another one that might have guaranteed pay. So this is that other policy that Linda was talking about. Bereavement leave might be paid and it might not be paid. So it depends on the employer and what the employer's policy was at the time that this law went into effect. So the requirement is that if an employer prior to January 1 of 2023 had a policy of paying for bereavement leave, the employer was required to continue that policy under this new law, continue the policy of paying for bereavement leave in 2023. So when we write bereavement leave policies for employers, we have to ask and check what the policy was doing before 2023. If we find out that the employer was not providing for paid bereavement leave, or it's a brand new company starting fresh after 2023, then that employer is not required to pay for bereavement leave. Employees have the option to supplement bereavement leave with other forms of paid time off, such as vacation, sick leave, PTO. But the employer is only going to be required to pay for bereavement leave if prior to January 1, 2023, the employer had a policy of paying for bereavement leave. And I've seen lots of bereavement leave policies, and there's been a wide mix of pay 1 day, pay 5 days, pay no days. So it just depends on whatever the employer was doing prior to this law going into effect.
Yeah, and I was just going to add, and it could be a mix, right? So you have the requirement of giving your employees 5 days off. You don't necessarily have the requirement of paying the 5 days. So let's take Ethos as an example. If Ethos's policy was as of January 1st or 12/31/22, I guess, that we would offer 3 paid days, I still have to provide the 5 days off, but I would only be required to pay the 3 days because that's what was in effect at the time this law went into effect. So that's why it's a little trickier than the other ones and why it may or may not be paid depending on that. So let's take a look at voting time. So this comes up at least once every year, right? Whenever there's going to be an election, you have a posting requirement, and then you typically do not have to pay for this. You would have to pay up to 2 hours of time off to vote if the employee does not have time to vote because of their schedule. In California, with the polls being open from 7 a.m. to 8 p.m., never happens, right? But if somebody, for example, was scheduled, I guess, 13 hours or more, maybe a firefighter or somebody that's on a 24-hour schedule, then it may apply. But otherwise, you just need to make sure that the employees have time off to vote.
Yeah, I get questions every election year from employers. Hey, I've got an employee who says they're entitled to paid time off to go vote. What do we do? And you got to remember that it's only paid time off to go vote if the employee is not able to go before or after work, or go on their lunch break, or go at some other time. So like Linda said, unless somebody's working 13 hours in a day, this law is probably not going to apply to someone. And especially now, since COVID, the voting procedures in California changed, where you can start early voting like a week before the actual election date. So for an employee to demonstrate that the employee is not able to vote because of work schedules, it's fairly difficult.
Yeah, I can't imagine now that anybody can take advantage of that, but you do have the requirement to post and notify everybody of the right to take the time off. So that's what's employer there. Okay, and then similarly, jury duty. So people get, selected for jury duty. You obviously must provide them with the time off. The pay on this one is a little bit different also, Curtis, because we're talking about difference for exempt versus non-exempt employees. What do you want to say about that?
The requirement to pay does get a little tricky and can be a little confusing. Also because the court will pay people who take time off from work to go and attend jury duty. It's like $8 a day. It's not much, and even then, the court asks people to waive their right to get paid for jury duty. So it can be confusing, and the my recommendation here is whenever it happens, either look up the specific requirements or contact one of us, and we can let you know what you're required to do as far as pay. But then there are many employers that voluntarily choose to pay certain amounts to employees as a voluntary benefit.
So I think the question we get asked a lot, Curtis, is I have a salaried exempt employee, they get called to jury duty, do I have to pay them? Right? And my answer is if they do any work, you have to pay them. And so how many employers are going to go sit at the courthouse and not answer a phone call, not respond to a text, not review their email, right? The most part, they're bored out of their mind waiting to get called. And so they're going to be doing work, which means you're going to end up paying, at least the exempt employees are going to end up paying, and the non-exempt employees for the time they spent doing that work. So I think that's the other thing that's tricky about this, but you do have to provide the time off. You do have to put them back in the same job. And I hope nobody gets called for a really long trial. All right, we get witness duty pay. Curtis, what's this one about?
This is a little different from what we've talked about before with crime leave or victims of domestic violence, sexual assault, or stalking leave. This is leave to participate in any judicial proceeding. So it's the victims of crime leave laws are limited to just the criminal proceedings. So this is actually open to civil proceedings as well. So any employee that's subpoenaed to appear as a witness in any court matter is eligible for leave under witness duty leave and can take time off to go to the court, testify, respond to subpoenas, and then come back to work. And those employees must be reinstated, and these employees must give notice requirements. I mean, the idea is if you're going to testify at a trial, you are served with a subpoena in advance. So when you receive that subpoena, you're supposed to give it to your employer and let your employer know, here are the dates that I might have to show up to trial and testify.
Yeah, and on this particular law, it's silent on whether or not employees can use vacation, sick, if they're required to use vacation or sick. So what advice do you normally give your clients, Curtis?
Yeah, so if an employee, it's kind of similar to jury duty leave. If somebody's sitting at the courthouse in the cafeteria or in the hall, just sitting around waiting their turn, and they end up doing work because they're bored, then you have to pay that time. But if somebody's actually going to take a day off and sit and do nothing, or sit and wait to get called and then actually go in and get called, then it would be unpaid.
So do you advise them they can allow the employee or should allow the employee to use vacation and sick?
I tell employers to allow it if they want to. I think that's acceptable.
But no requirement. Okay. All right, we've got a couple of different school leaves. So this first one is time off to visit school authorities. So this is basically a requirement for every employer. So if the parent or guardian, right, it could potentially be grandparents or such, are called to the school, mostly because your kid's going to get kicked out of school, then the employer is required to give that time off. It usually isn't even a full day, right? It's like show up for this parent-teacher conference or go to the principal's office or whatever it is, but it's just a requirement. So you can go discuss whatever your child's doing. And then the second one, though, is a little bit different, Curtis. This one is, I guess, for more fun reasons to go to school.
Yeah, the first one's for disciplinary reasons. Your student, your child has been ditching out or has behavior problems. But this one is to participate in school activities such as concerts or
Plays,
performances, plays. Yeah,
sports, right. Whatever it is. Yeah.
Because this is a little more of a broad requirement. It only applies to employers with 25 or more employees at the same location. And it's only for employees with children in grades kindergarten through 12 or in a licensed child care facility. And again, the idea is to participate in fun stuff. And it's up to 8 hours per month, and it's up to 40 hours per year. It's unpaid, but an employee can choose to supplement with accrued paid time off.
All right, great. Okay, and then our last leave, before we get into a couple general comments, is the Employee Literacy Education Assistance Act. Again, one I've never had anybody take, but this applies to employers with 25 or more employees. And this is an employee that needs to enroll in some sort of literacy education, English as a second language, whatever it is. So they can enroll and participate in that program, and you're essentially giving them time off to attend classes is what it comes down to. Have you ever had anyone take this one, Curtis?
Yes and no. So I have dealt with it, but it's usually in situations where an employee wants to take classes like at night, and so they want to leave early. So what I've done in the past is just work with the employer to change the employee's schedule so that they
Right.
still work their normal full-time hours and then are able to go and take their classes. So it's no in the sense that I've never actually had anybody take time off from work, but yes, in the sense that we've worked with employers to adjust schedules to allow it to happen.
Exactly. All right, great. So couple of general comments we wanted to talk about. The first thing is when I'm talking to a client and I'm trying to explain leaves of absence, what I advise everybody to do is think about time off different from pay, right? So they get jumbled together and it gets very confusing. So the first question you need to ask is whether or not the employee, when they come to you, is eligible for any leaves under the law or under company policy, because you could potentially be offering a benefit higher than what the state or federal government's requiring you to do. So how much time off is provided, take a look at each of those different laws. And then once you know if time off is provided, then the second part is whether or not there's any financial resources available. And that could be something from the state, like state disability insurance. It could be workers' comp. It could be under companies' paid time off policies like vacation or sick or PTO. There's also paid family leave, right, for taking care of a family member, and that's through the state as well. So we just wanted to point out that that's really the analysis. Keep it separate to make it easier, right, to consider whether or not there's any time off available and then whether or not there's any pay available. Anything you want to add to that, Curtis?
Just want to reiterate what you said, that these are different considerations and they need to be analyzed and considered separately. I often tell employers that first, for the time off, you think of this as employee's right to not come to work. And then after you've analyzed the employee's right to not come to work, then you can analyze if the employee is entitled to any kind of pay or has available any other kind of pay for not coming to work, such as from the state, from insurance, or from an accrued benefit.
Well said. Okay, and then Curtis, let's take this one. You can take the last two slides actually, and then we'll answer any questions that you've dropped into the Q&A section. So let's talk about penalties for non-compliance, because they can be pretty serious.
Yeah, so we've listed some out here, and I also want to add that a lot of these leaves of absence come from the labor code, California labor code. And anytime an employer violates a provision of the labor code, that the employer could be subject to PAGA penalties. And PAGA is the employment lawyer's nightmare right now. We hate PAGA. And just know that even though we've listed a lot of bad things that could happen, a lot of money that you'd have to pay, you could also be subject to PAGA, which is also very expensive and very much a large headache.
Absolutely. And then another law that got changed earlier this year, Curtis, is the retaliation. And this one is like totally scary to me, right?
Yeah, this is also upsetting a lot of the defense-minded employment attorneys like myself. So January 1st of this year, the law says that if any employee engages in a protected activity under the labor code, then the employer cannot take any kind of adverse action against that employee for a period of 90 days. So often I get this question, I want to terminate somebody. Can I? And I have to go through the list of, well, have they done this? Does this apply? What are the red flags? And now I have to have this conversation of, have they gone on any leaves of absence in the last 90 days? Have they taken paid sick leave in the last 90 days? Because there is a presumption of retaliation now if an employer engages in any adverse action against an employee who has taken any kind of protected activity within that previous 90 days. It's a rebuttable presumption. We can still, after an employee says, hey, you retaliated against me, the employer can still rebut or disprove that presumption by demonstrating a good faith, non-retaliatory business motive for the action. But still, this law just makes it so much tougher for employers now.
Absolutely. I mean, it was 30 days before for certain activities, and now that it's 90 days. So potentially somebody could take sick pay. Like I've had this come up already this year. Somebody takes paid sick leave, right? But they've been sort of on that slow walk out the door, right? And the employer's been documenting performance issues, but then they take sick pay all of a sudden or something else. You know, they serve jury duty. It could be almost anything. But if they do something that's a protected activity, and then the company ends up firing that person, you're going to have an argument, right? So, and this is a $10,000 per employee per violation fine. So,
plus attorney's fees, plus emotional distress.
right, plus everything else.
Yeah.
Yes, absolutely. All right, and that is it. So, Denise, I'm going to turn it back over to you, see if anybody has any questions that they would like answered. I'm glad that we split these up because it took us an hour last time and we barely made an hour to get through all of the personal leaves. And now we've covered 21 in 45 minutes. So that's pretty good.
I think everybody's shell shocked by the amount of leaves that are available. I think that's a big part of it.
They should be.
Yeah. So we have a couple questions that came in. For the bereavement leave, is it possible to create a policy of a paid leave for first degree relatives, so a spouse, parent, or child, and then have a policy for unpaid for things like grandchildren or someone else?
Absolutely. Yeah. So setting aside the date that we talked about, like, you know, so just if this is a generic question, not relating to what we talked about with bereavement leave, right? Because again, as to Curtis, what he said, you'd have to find out what they were doing as of January 1st, 2023. But setting that aside and assuming it's just a general question, yeah, you can. So you could have a policy that says, hey, we're going to give you 3 days, 5 days, whatever paid leave for what we'll call immediate family, and then less time for other family members, cousins, aunts, uncles, whatever. We write those policies all the time. In the ethos policy, we actually wrote in dogs because we've had a few of our employees, unfortunately, lose their animals, which is a family member. So, you know, to me, it's no different. So we offer, I can't remember if it's 1 or 3 days, but we offer at least 1 day off when somebody is, you know, has to lose their poor dog.
I want that benefit. Not that I want my dog to
Right?
something happen to my dog, but
that's just it. I mean, so people, you know, we all think about the kids and other family members, but you know, we discussed it and I was like, yeah, I hope it doesn't happen, but it happened like 3 times last year. We had people on our team lose dogs. So yes, so you can write the policy however you want, because again, it's a requirement to give the time off. It's not a requirement to pay unless you had that in effect. So you can do pretty much whatever you want, subject to those restrictions.
if it's a voluntary benefit, then you can condition however you want.
That's pretty good. That speaks to your culture right there, Linda, with the dogs and stuff. So I have a question here, and the question as it's stated, does an employee have to request a leave of absence, FMLA, CFRA, etc.? But perhaps a better way to look at it is, like, do you have to establish a policy internally on how employees have to request leave of absences?
I love this question. Curtis, you want to go? Or
If you're asking about, if the question is about FMLA or CFRA, then my recommendation would go back and watch the webinar we did last month. because we discussed that in that webinar, because sometimes the employee has to formally request it, and sometimes the employee doesn't have to formally request them, and you have obligations to provide notices and interact with the employee depending on the leave and the circumstances. But for the 21 leaves we talked about today, just going through the list in my mind, I think these are all policies that the employee must request to take. Linda, can you think of any that we talked about today? Or
No, I would just step back and take a more general, higher level answer, I guess. Employers have an affirmative obligation to let employees know about most of these leaves. Curtis and I were discussing before we started this webinar about the reproductive loss leave, because neither one of us have found a notification requirement, which is unusual because most of the time the law says, oh, if you have specific knowledge that somebody needs time off, or if they come to you. So let's just say I have some sort of medical condition. Well, I'm going to wish that out in the cornfield. Somebody comes generically and has some sort of medical condition, and you as the employer go, oh, wow, like let's take pregnancy. That's an easy one, right? Somebody comes and shares the great news that they're pregnant, right? We have an obligation as an employer to notify them that they have certain benefits under the law, including time off, right? So I would say don't ever ignore that. You don't have to run around asking everybody every day if they need a leave of absence for something, but you need to know under what circumstances employees are required to request it, like a lot of the leaves today, or under what circumstances would you have a requirement to offer it? And you need to train your managers. So should you put in a handbook a policy for how they should notify somebody? Absolutely, in my opinion, right? You want to make the employee clear that, hey, if you need a leave of absence, either go to your supervisor, go to HR if you have HR, whatever it is. That would be ideal, but you still might have an obligation to go to them if for some of these leaves, like personal medical leaves.
Okay. Must we ensure that our timekeeping systems list each type of leave as an option to take time again? So I guess so that their timekeeping system
to track leaves.
To track it, yeah.
Yeah, I mean, I don't think so, because it's really for your benefit to track the leave, right? So that would be a lot. You're talking like 25, 26 different line items that you would have to put into a system. So some of the larger ones probably have the ability to get that set up, but I don't know that there would be a requirement, Curtis, to do that.
Not that I know of. I mean, it's still a best practice to track someone's leaves of absence. But I don't think you'd have to necessarily do that in your payroll system.
Yeah, because it doesn't have to be reflected on a pay stub or anything like that. In fact, you won't have a pay stub if the person is not working that week, right? So it's more for internal tracking purposes.
Right.
And if you can do it in a payroll system, then I would say, yes, do it, because you're going to be able to run reports. They're going to show that, right? And it's going to be easier to track than doing it manually, but you don't have to have them all split up separately.
Okay, someone just was asking for the recording for the previous webinar. Just go to the Ethos or Merhab Robinson YouTube channels, and you'll be able to find the recording from last time.
Yeah, ours is youtube.com/ethos HCS, just like my email address. So it's easy to find, and you can take a look at that. Were there any other questions, Denise?
Nope, that's it. Like I said, I think everybody's just overwhelmed by the amount of leaves that you have to understand when you're an employer.
Completely. So with that, I'll just say thank you for attending. If you have any other questions regarding leaves of absence, please reach out to me or Curtis, and we're happy to help you. Our next webinar is going to be on June 6th at 11 a.m., and that is going to be on the Workplace Violence Prevention Plan. That is a requirement that goes into effect July 1. Most employers, if you have 10 or more employees in a location, are going to be required to have this in writing. Or if you have even a smaller employer that's open to the public, you're required to have a plan in writing. And it's pretty extensive. It's sort of like COVID prevention. You had training requirements, you had logs, you had all sorts of things that you have to document. So we're going to walk you through those things next month. And then I put the link right there to register. So Denise, as always, thank you for moderating. Curtis,
No problem.
thank you for being our partner in crime here. All right, everybody, thanks so much. Have a great rest of the week.
Thank you. Bye-bye.